Abraham Lincoln. In law, it is good policy to never plead what you need not, lest you oblige yourself to prove what you cannot. New York Times. Hold my beer. Viva Frei, Montreal litigator turned YouTuber. I know I said I wasn't going to do a vlog today, but what can I say? I have a problem. There, I said it. New York Times recently ran an article, a bombshell of an article, detailing alleged misconduct by Brett Kavanaugh. More alleged misconduct by Brett Kavanaugh. The bombshell of a story as it was initially run was that Brett Kavanaugh was at some sort of drunken Yale party and is alleged to have placed his private parts in the face of another partygoer. The New York Times then ran an opinion piece which they posted to Twitter with the shockingly offensive and sensationalist headline that read as follows. Having a blank thrust in your face at a drunken dorm party may seem like harmless fun, but when Brett Kavanaugh did it to her, Deborah Ramirez says, it confirmed that she didn't belong at Yale in the first place. I think most of us can agree that that phraseology is crass, sensationalist, and more akin to tabloid journalism than the old grey lady, and the old grey lady admitted as much when it deleted the tweet with the following comment. We have deleted an earlier tweet to this article that was poorly phrased. Now there is poorly phrased and there is poorly phrased, and calling that poorly phrased does an injustice to what poorly phrased means. That was not a question of poor phraseology, that was a question of poor judgment. But it gets worse for the New York Times. So they run this bombshell of a story which actually starts trending worldwide about how 30 some odd years ago Brett Kavanaugh is alleged to have placed his private parts in the face of a woman at a Yale party. The next day, they ran something of a material correction to the original story, which reads as follows. Editor's note, an earlier version of this article, which was adapted from a forthcoming book, did not include one element of the book's account regarding an assertion by a Yale classmate that friends of Brett Kavanaugh pushed his blank into the hand of a female student at a drunken dorm party. The book reports that the female student declined to be interviewed, and friends say that she does not recall the incident. This information has been added to the article. This information has been added to the article as though it provides some sort of clarity. This information is the reason for which the article ought never have been run in the first place. And it brought me back to the wisdom and seemingly timeless quotes from Abraham Lincoln. For those of you who don't know, I think I have a bit of a fetish for Abraham Lincoln, but I'll get over it one day when I go through all of his amazing quotes. But his quote from the practice of law. In law, it is good policy to never plead what you need not, lest you oblige yourself to prove what you cannot. In other words, don't allege something that you cannot prove. And there are multiple variations, albeit less eloquent, of these words of wisdom by Honest Abe. But this is not just relevant to law, it is relevant to life, and it is certainly relevant to journalism. Dear New York Times, in journalism, it is good policy to never plead what you need not, lest you have to prove what you cannot. And in law, when you sit down and meet with a client, you go through their story and they give you all of the facts, they give you their opinion, they tell you what they think, they tell you where they want to go with the file, they tell you what needs to be proven, and your job as an attorney is to sit down there, listen to the facts, gather the evidence, and then say, what am I able to prove? Because at the end of the day, it doesn't matter what someone says, it doesn't matter what you say to the judge, it matters what you can prove to the judge. And it's nice to think you know something, but in law that is irrelevant. What is relevant in law is whether or not you can prove it. If you can't prove it, all you are left with is a baseless allegation for which there is no evidence. And guess what? That can lead to claims of defamation. And sometimes the clients don't like it, they get mad at you. They say, I know that my neighbor poisoned my dog, I know it was him. And I say, okay, but do you have a toxicology report from the autopsy? No, we had the dog cremated. Do you even have evidence that the dog was poisoned? No, we had the dog cremated, we didn't do any tests. Did you find any poison in your backyard? No, I didn't find anything in my backyard. I once saw these little pills that dissolved into the rain, but I didn't keep them. Okay, then what evidence do you have that your neighbor poisoned your dog? I know he did it. He never liked my dog, he always made faces at my dog, and he always got mad that my dog was barking in the backyard. I know that he did it. At which point a responsible attorney should say, I understand that's what you believe. That may even be true, but we don't have one iota of evidence to make the allegation. And if you make the allegation that your neighbor poisoned your dog to death, if you make that allegation without the slightest shred of evidence, guess what? It can come back to bite you in the butt. And bringing this back to the New York Times, they run a bombshell of an article, and thanks only to the investigative journalism of some other third party, they come back and make the small editorial correction that in fact, they have no first-hand evidence that this ever occurred, that the primary witness refused to go on record, and that according to her friends, she doesn't even recall the incident that the New York Times is now reporting as fact. All right, I should open two parentheses here. First of all, to give credit where credit is due, apparently it was one Molly Hemingway who first pointed out the New York Times omission as relates to the Brett Kavanaugh bombshell of the story. Second parentheses, just so that no one accuses me of mischaracterizing the practice of law. When I refer to the initial meeting with a client where a lawyer gathers the information in order to determine what he or she can prove or cannot prove before a court of law as relates to what allegations should be included in the procedure, there is something that we've discussed before, the discovery process, examinations, depositions, request and communication of undertakings from the opposing party. It is quite possible that in the context of a lawsuit, certain facts come up that you then add to your lawsuit because you have now discovered the necessary evidence to prove those allegations. Other times it's going to come out that you think you have an allegation that you are able to prove, and it becomes clear during the discovery or litigation process that you are in fact unable to prove that allegation. And that is why lawyers can amend their proceedings pretty much as often as they want, to the extent that it doesn't run contrary to the ends of justice, but a lawyer can amend their proceedings to add new allegations if they discover evidence that allows those allegations to be proven. They can strike other allegations if it becomes clear that they're going to be simply incapable of proving those allegations. The litigation process itself is a long and windy road. A road with many bumps, twists, and turns, but all that to say is that a lawyer has to be careful as to what they allege in their proceedings. They can make up for certain errors, they can add allegations later if they think they can prove them, but whatever, that might be a vlog in and of itself. Let's just get back to this vlog right now. And this is the reality of law. If you make a baseless allegation in front of a judge, it hurts your credibility as an attorney. It hurts your client's credibility as a party to the suit. And the more egregious, salacious, prejudicial the allegation, the harder the judge is going to come down on you, the more your credibility is going to be damaged, and the more you're going to have to do in order to reestablish your credibility in front of that judge. And when the New York Times publishes these types of stories as fact, only the next day to come back with material corrections that they in fact had no evidence for making the allegation in the first place, that the immediate witness to the alleged act refused to go on the record, and that all of her friends say that she doesn't recall it in the first place, that is not a material correction to add specificity to an article.
That is a reason for which the article ought never have been run in the first place.
That is tantamount to making the most salacious, prejudicial allegation of an opposing party in a lawsuit, only to get in front of the judge and say, yeah, sorry, I don't really have any evidence for that, so let's just go ahead and strike that. That is the point at which, incidentally, as an opposing party, I would refuse to allow that allegation to be struck from the file, because I would use that against the party who had made that allegation for a claim in defamation against them. Alright, and bringing this back to the question of losing credibility in the eyes of the judge. New York Times, your readers, the general public, the world at large is your judge. And when you publish a story that turns out to be in fact materially, factually incorrect, and you run some erratum as though, we missed a detail, but that's not a detail that you missed, that's actually a reason why you ought never have published the article in the first place. You are compromising your credibility in the eyes of the public to a point where it's going to take so much more to reestablish your credibility that you may not ever be able to do that again. Okay, I'm sorry. I haven't eaten breakfast and I haven't had a cup of coffee yet, so I'm getting a little excited, but that is a very, very, very big issue. In law, they say it takes years to build a reputation and minutes to ruin it. And when a lawyer makes an error in judgment that compromises their reputation, it's going to take more than the years that it took to build that reputation in order to reestablish that reputation.
If that can ever be done.
And for anyone who thinks I'm picking on the New York Times, this has nothing to do with the New York Times per se. This is all mainstream media. I promise you, in 5 to 10 years' time, universities are going to give a course on how to read mainstream media news. Because even the Fox News article reporting on the New York Times gaffe editorializes the headline. New York Times forced to run editor's letter, notes that new accuser doesn't recall alleged assault.
Don't allege what you don't need to, lest you be forced to prove what you can't.
How does Fox News know that the New York Times was forced to run an editor's letter? They did it, that we know. Were they forced to? Who knows? Who would have forced them to do it? Was it their CEO that forced them to do it? Were they even forced to do it in the first place? Or did they do it voluntarily in order to remedy what was an honest mistake? I suspect it has always been this way, but I haven't been as aware of it. But we live in a world now where editorializing headlines and the news is the rule and not the exception. And then when we click on the editorialized headline of the Fox News article, the actual headline of the article reads as follows. New York Times updates Kavanaugh bombshell to note accuser doesn't recall alleged assault. And here we can see the difference between alleging something that you need not allege, that you might be forced to prove that you can't, as in they were forced to issue an editor's letter, versus just an actual statement of fact in that they update the original article with a correction, a minor correction, that the witness doesn't recall the incident. But they ran the story anyhow, without mentioning that.
That's journalism these days.
So that is the vlog today, and the lesson of law and life that we can extrapolate from irresponsible journalism. Incidentally, I did a video on the Brett Kavanaugh, Christine Ford saga a while back. I'll post a link right here. And in that video, I sort of break down both sides of the story, whether or not you vehemently disagree with one side or the other. I did a video just basically breaking down both sides in as objective terms as possible, because one has to nonetheless understand the opposing side, even if they disagree with it. When someone ends an argument by saying, I don't even understand how you can think that, they have not won the argument. You do not win an argument by refusing to understand the other side's position. In fact, that's how you lose cases. One has to make an effort to understand the other party's position if one is going to disagree with it and prove it wrong. So that's that. If you like my content, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section, share my video, share my channel with someone who you think would appreciate it. If you want to get some merchandise, I will put the link in the comment section below. And now you know your vlog. Peace out. Boom!